friends, how are you? In the today's lecture series, I will discuss the basic fundamental and the basic parameters regarding the cancellation of bail, specifically in the case under the Prevention of Corruption Act. Usually, when we apply for the bail, we submit certain facts in support of our innocence. It is a basic strategy of the concerned prosecution that the offence is of serious nature. There is a demand, acceptance, recovery of money, or sometimes they plea on the point of collusion and conspiracy. And it becomes very much difficult to get the bail before filing of charge sheet, and even though you got the bail, they usually move for cancellation of bail. Even though when you get the anticipatory bail, in that scenario, definitely the state moves before the state for cancellation of the bail as per the protocol of section 439 subclause 2 of CRPC. So in that scenario, what should be our strategy, what we could do, and how to be ready to deal with such problems is going to be discussed by me in the present video. The present video is not the outcome of my personal thought, of my personal discussion, but rather than it is the example chalked out by the concerned High Court while dealing with such type of problem. I will discuss everything in the detail. Be patient. Just note down what I am going to narrate you, so that if you are having the same problem, or if you may in near future, then you could easily encounter such scenarios without any worry, without any tense. Friends, topic is very important. I am going to start the presentation. Let's move on the screen. Friends, in this case, the state has moved the application for cancellation of bail. The basic provision for cancellation of bail is incorporated in section 439 subclause 2 of CRPC. It means whether it is a regular bail or an anticipatory bail, but if the state inter alia moves for cancellation, the state has to file the application before the concerned court or the concerned High Court by which the bail has been inclined as per the protocol of section 439 subclause 2 of CRPC. In this case, the original accused has been inclined on bail by the concerned Sessions Court, and the offence was concerned with section 7 and 13(2) of the Prevention of Corruption Act. Usually these offences are not critical, but they are made serious by the agency itself, because without doing the proper verification, they believe that you are a culprit once a certain voice of you is in picture in the form of recording. The Honorable Supreme Court emphatically emphasized that the concerned police is bound to hold the preliminary inquiry for the purpose satisfaction. But how they hold inquiry? Give the recorder, record the voice, make the transcript, and you are a culprit. It is a nonsense practice, not a legal practice. I am fairly and frankly speaking. So you have to emphasize that whatever they are going to do, they may do. But whatever we have to do, it should be as per the norms of law. Friends, in this case, the concerned public prosecutor submitted that the impugn order ex facie means prima facie. It is illegal, arbitrary, and it is passed without appreciating the fact and circumstances of the case. And he submitted that the cancellation of bail application should be allowed, and the bail granted to the accused should be cancelled. On the other hand, the accused has appeared because the accused has a right to make the submission as per the right given to him by the virtue of principle of natural justice. So he objected the submission. Submissions are that after evaluating the evidence placed on the record and after taking into consideration all the relevant aspects, the impugn order deserves no interference and the application deserves to be dismissed. Now we are coming on the observation passed by the concerned trial court while passing the impugn order and while granting the bail to the concerned applicant. Friend, in this case, the court specified that I have perused the impugn order and the order passed by the concerned trial court granting bail to the concerned accused. The court submitted that I have considered the submission submitted by the concerned counsels appearing on the behalf of the parties and their averment in the application. Further, from the record, it appears that after a long span of time, it means from 2018, there is no overwhelming circumstances is reported against the accused. There is no breach of condition by the accused. It is relevant to note that there is no any prohibitory order. Investigating officer has not filed any charge sheet on the ground that the FSL report was received. However, even thereafter, also the investigating officer has not filed the charge sheet before the concerned court, even though in this case the FSL report has been received in the year of 2022. And that's why trial court felt impediment in this way, and that's why not proceeded in the matter further. So the key point is that the court specified that I am of the opinion that the trial court has rightly exercised the power The court emphasized that there is a difference between the parameter to be applied while considering the bail application, as well as the parameter for deciding a petition for cancellation of bail application. And the court emphasized on judgment of Honorable Supreme Court in case of Puran versus Ram Vilas, judgment cited as 2001 SCC page 338. It was retrieved that at the time of deciding the application for bail, it would be necessary to record reason, and without evaluating of the merits of the case, the bail order should be pronounced. In the case of Puran, as mentioned above by the Honorable Supreme Court, the court also emphasized on judgment of Gurcharan Singh versus State, which is reported in 1978 volume 1 SCC page 118, wherein it is observed that the bail once granted should not be cancelled until and unless the new circumstances and evidence should come on the record which could satisfy the higher court that while exercising their jurisdiction, why they should interfere in the impure order. Apart from that, the court also emphasized on judgment of Deepak Yadav versus State of Uttar Pradesh. In this case, it is observed that the principle of cancellation of bail are quite differ from the principle of granting of bail. The court specified that once the bail has been granted, it should not be cancelled in the routine or mechanical manner. The supervising power should be exercised to assure that the trial court has committed the illegality. If there is no illegality apparent on the record in that scenario, merely on the ground that the application for cancellation of bail has been filed, the court should not interfere. Apart from that, the two-bench judge of the Honorable Supreme Court in the case of Daulat Ram versus State of Haryana has specified certain guidelines for cancellation of bail, which are interference or attempt to or interference with course of justice. Number one, because sometimes the accused after getting the bail threatened the concerned witnesses, tried to hamper the investigation. So in that scenario, if such scenario are occurring or occurred, in that scenario the concerned victim could move before the higher courts for cancellation of bail. There should be an attempt on the part of the accused to evade from course of justice. For example, the conditions are that he should not leave India without the prior permission, and he is about to leave India and he is preparing the passport in the illegal way. So that may be a considerable factor that he is trying to evade and trying to flee away from course of justice. Apart from that, he has abused the benefit or concession granted to him in the form of bail, and possibility of absconding, possibility of misuse of bail, likelihood regarding tampering or threatening the alleged witnesses. So it may be a considerable factor to cancel the bail. Otherwise, the bail should not be cancelled in the routine manner. Apart from that, the court has specified judgment of Hitesh Kumar. Apart from that, judgment of Anil Kumar Yadav also deserves special mention here, in which it is specified that one discretion is exercised by the concerned court of session to grant the bail on the relevant facts. It should not be interfered until and unless there are some compelling circumstances on the record which are totally overlooked by the concerned trial court. So looking into the fact and circumstances and the legal position laid down by the Honorable Apex Court, the court specified that there is no error, and ultimately the petition for cancellation of bail filed by the state is hereby declared dismissed by the concerned Honorable High Court. So friends, we could conclude that whenever the application for cancellation of bail is moved, it is quite differ from granting of bail. The bail should not be cancelled in the mechanical manner. The bail should not be cancelled once granted. The overwhelming circumstances should be on the record. So whenever you are going to oppose the said applications, just file the reply, do the proper study, support your argument with the law laid down by Honorable Supreme Court and the concerned High Court of that state. If the High Court judgment is not available, then you may consider the judgment of other states. So your rights are in your hand. If you are able to protect them, secure them. If you could not, then everyone will have the mockery of you. So it is your right. Save it. Do not be the mockery of those who never respect the rule of law. So it is an important legal topic. For such updates, please subscribe my page. Please share this video. So friends, see you in the next video. Till then, Jai Hind, Jai Bharat.